I'm Dion Tracy Duckett, elder law and estate planning attorney in the Atlanta, Georgia area. Today, I'm talking about estate planning with wills and trust. I hope that this video will provide a good foundational overview of how you can use wills and trust in your estate planning. So when we talk about estate planning, the first question that we need to answer is, what exactly is your estate? Your estate consists of everything that you own: your house, your bank accounts, your insurance policies, your clothing, all of your property. It also involves your loved ones, your values, and your legacies. The next question people ask is, why should you plan? So there are several reasons for planning your estate. One is to designate who you want to care for you and your property if you should become incapacitated. There are several reasons for planning your estate. And estate planning isn't just about planning for the distribution of your property after you die. One key reason to plan your estate is to designate who you want to care for you and your property if you should become incapacitated and can't care for yourself and manage your property for yourself. An estate plan allows you to designate who you want to manage your estate when you die. An estate plan also allows you to designate who you want to care for your minor children if something should happen to you. And finally, we often say that the purpose of an estate plan is to give what you want, to whom you want, when you want, and the way you want. So what happens if you don't plan? This can lead to possible expensive court proceedings if you should become incapacitated. So we're talking about guardianship and conservatorship proceedings. A guardian is someone appointed by the court to manage your care if you're unable to manage your care for yourself. And a conservator is someone appointed by the court to manage your property if you're not able to make reasonable decisions and manage your property yourself. And so often there's expenses incurred: lawyers' fees, court fees, and time delays. With these proceedings, the court will decide who will manage your care and who will manage your property. If you die without doing estate planning, then the state has a plan for you, and the statute will determine who receives your property when you die. So who should have an estate plan? Anyone over the age of 18 or older should have an estate plan. You should at least have the incapacity planning in place. Estate planning is not just about planning for death. What happens if you become incapacitated? Who's going to take care of you? And who's going to manage your property? When we think about estate planning, we should also consider possible threats to your estate and to your family's inheritance. Some of these threats include incapacity, immature or irresponsible heirs, spousal remarriage, blended family, irresponsible spenders, substance abuse issues, and self-serving caregivers. All of these things should be considered when you're making your estate plan. So let's talk about wills. A will is a legal document that provides for the distribution of your property when you die. A will also designates your preference for guardians to care for your minor children. With a will, probate is required. Many people think that if there's a will in place, the executor can simply take the will and start doing what it says, but that's not the case. You actually have to file the will in the court and petition to have it proven as valid and to have the executor appointed. Once that's done, then you must go through the probate process. So the probate process. With the probate process, as we mentioned before, the court determines the validity of the will. Once the court has determined that the will is valid, then the court will appoint the executor and issue what's called letters testamentary, which gives the executor the right to administer the decedent's or the deceased loved one's estate. Often, a bond must be posted, An inventory must be filed, and annual reports must be filed until the estate has been totally resolved. Once the court appoints an executor and issues the letters testamentary, notice must be published in the newspaper for 4 consecutive weeks. This notice is to give notice to creditors and debtors and allow creditors to file claims against the estate. Creditors then have 3 months after the last date of publication to file their claims. During this time, the executor is securing and inventorying the property. During this time, the executor should not make any distributions of property. At the end of the 3 months, the executor then determines which of the claims are valid and which ones have priority. The statute determines the order of priority, because if there's not enough money in the estate, then the debts have to be paid in the order of priority. Once this has been determined, the executor pays expenses and valid claims. After all expenses and valid claims have been paid, then the executor can distribute the property to the heirs. The entire probate process usually takes a minimum of 6 to 8 months and can take years. So now let's talk about trust. A trust is a legal entity that separates legal ownership from beneficial ownership. You can think of a trust as a treasure chest for the ownership of your property. When you create a trust, you usually transfer all of your property into the trust. And once you do that, the trust is now the owner of the property. You no longer own the property. In the trust agreement, you designate agents who will manage the property for you. So the trust agreement is basically a book of instructions for the management of your property. So typically, you'll be the initial manager of the property, so you'll be managing the property for yourself. The trust agreement also provides instructions for how you want the property managed. Because the property is now owned by the trust and not by you, it allows you to avoid probate. Probate deals only with property that's owned in your name alone at the time of your death. When we talk about estate planning, we're typically talking about a revocable living trust. There are many types of trusts that we will not talk about today. So a revocable living trust is one that's created while you're living, and then it can be amended or canceled altogether. As we discussed, one of the benefits of the trust is to provide for management of assets if you should become incapacitated. This allows you to avoid costly conservatorship proceedings in court. A trust also allows you to avoid probate. A trust can provide protection for your family's inheritance. And finally, the trust can help promote family harmony by spelling out what your wishes are for the administration of your estate and for your care if you should become incapacitated. So we mentioned earlier the threats to your estate and your family's inheritance. As a reminder, those are incapacity, immature, irresponsible heirs, spousal remarriage, blended family issues, irresponsible spenders, substance abuse issues, and self-serving caregivers. So when we talk about incapacity planning, that is one way to help prevent the loss of assets. When you conduct your incapacity planning using a trust, you designate successor trustees to manage your property if you should become incapacitated. This way, you are able to designate who you want to serve, rather than have a court designate someone to serve for you. If you fail to plan, then court processes will be required to appoint a conservator. You will have no say in who is appointed. Family members may fight over who should be appointed. It could be a total stranger, or it could be a family member who you didn't want to be in that position. The conservatorship process is a public process that takes away your rights. Incapacity documents, in addition to the revocable living trust, include the Advance Directive for Healthcare. In Georgia, that document includes the power of attorney provisions and living will provisions. The power of attorney provisions appoint agents who you choose to make healthcare decisions for you when you can't make them for yourself. And the living will provisions provide your instructions about how you wish to be treated if you are in a terminal condition or if you're in a permanent state of unconsciousness. And then there's the financial power of attorney. In the financial power of attorney, you're able to designate an agent to manage your property if you're not able to do so. Let's turn to immature heirs and irresponsible spenders. There was a study conducted in 2012 of people in their 20s, 30s, and 40s who received inheritance. In the study, 34.9% of inheritors saw a decline or no change in their wealth after receiving an inheritance. 1 in 5 young baby boomers who inherit a significant amount of money spent or lost all of it. The average participant spent roughly half of the inheritance. So, taking all of this into consideration, your heirs may be young when you die. Heirs become entitled to inheritance at the age of majority if you haven't done planning in advance to control that. Grandchildren may be heirs if your child dies before them. And heirs can be infants or small children. When we consider spousal, remarriage, and blended family issues, you want to think about, will your surviving spouse's new spouse receive your property? If you die and you leave all of your property to your spouse, then what happens to your goals for your children? What if the new spouse also has children? Will your money be given to the new family? There are similar issues when it comes to blended families. Spouses often have children from previous relationships, and spouses often create sweetheart or I love you plans in which each spouse leaves everything to the other spouse and then to the children. So in a blended family situation, the spouse may say, if I die first, then I want all of my property to go to my spouse. And if he dies before me, then I want it to go to all of our children. So what happens when the spouse dies? The first spouse dies. Will the surviving spouse continue to protect your children? Will the surviving spouse change your plan? These are questions that should be considered when you're doing your planning. When it comes to substance abuse issues, sometimes we have loved ones who struggle with addictions. So how will an inheritance impact them? Will the money be spent to feed the addiction? Will they end up in a worse position? How do you address this concern? Do you disinherit them because of the addiction? With a trust, you can provide for your loved one and provide control over the inheritance. And then there's the issue of dementia and self-serving caregivers. In a special report published by the Alzheimer's Association, they show that over 6 million Americans aged 65 and older have Alzheimer's disease. This number is expected to increase to nearly 13 million by the year 2050. They show that 1/3 of seniors die with Alzheimer's disease or some other form of dementia. In the United States, Alzheimer's and dementia deaths increased 16% during the COVID-19 pandemic. Seniors are often targets of fraud and victims of caregivers. Caregivers spend a lot of time with seniors. They often develop trust, which leads to their ability to gain access to assets. There have been instances where caregivers have added their names to the accounts of seniors. There have been instances when caregivers have had their names added to the accounts of the seniors under their care. Then when the senior dies, all of the money goes to the caregiver. There have been other instances where caregivers have convinced seniors to leave their estate to the caregiver. And again, the heirs are disinherited. So what about your children's creditors? So what do you do if you have children who have financial problems? Do you want their inheritance that they receive from you to go to their creditors? What if your children get divorced? Do you want your former son-in-law or daughter-in-law to be at risk? Is there a risk that your child's inheritance could go to your former disgruntled son-in-law or daughter-in-law? A revocable living trust can provide protection for you and your heirs. By designating successor trustees, it helps you to plan for management of your property if you become incapacitated. If you've properly funded your trust and transferred your property to the trust, then you can avoid probate costs at your death. The trust can help protect against spousal remarriage or blended family issues because the provisions that you've made in your trust will become irrevocable on your death. That will prevent the spouse from changing your plan. The trust can also protect against fraud and self-interested caregivers. The trust does this by placing trustees in place in the event of incapacity. The trust can also provide protections against your family members' loss of inheritance due to addictions, financial issues, immaturity, and other issues, because the trust can put controls in place and trustees in place who will manage the property and help prevent these losses. The time to plan is now. Failure to plan can lead to a loss of assets. There can be costs incurred due to your incapacity if you have to go through court proceedings to have a conservator appointed to manage your property or a guardian appointed to manage your care. There can also be a loss of inheritance for loved ones if you fail to plan and put controls in place. Accidents happen every day. If you should be in an accident or develop a disabling condition or illness that also impairs your capacity, you may not be able to implement an estate plan. In order to put an estate plan in place, you have to have the mental capacity to do so. No one else can do it for you. So everyone age 18 or older should have some type of plan in place. At Duckett Law, we can help. To schedule a consultation, please contact us at info@duckettllawllc.com or 404-349-2220.